Hi, my name's Sharon Mackay. I'm the Head of Family Law Department at Taylor Bracewell. So financial remedy proceedings are proceedings separate to but within a divorce. So a divorce would need to be started, and if two parties have got to the situation where they haven't been able to reach an agreement on financial settlement, so it might be that they've tried face-to-face or through solicitors, the next step would be that we would have to refer to mediation. So mediation is where they would go together with a trained mediator to try and see whether they can resolve finances there. They would have to disclose their assets, income, debts, etc. to each other. And if after mediation, if it breaks down without a settlement, or if one party won't go to mediation, then it would be open to one of the parties to apply for financial remedy. So what that means is a process whereby the court would then become involved in assisting them to resolve their finances. They would have to deal with a long statement of their means called a Form E, and then they have to exchange those Form E's and then raise further documents. And the first court appointment generally doesn't take place for at least 3 or 4 months. Now, those hearings are still taking place remotely, but it may be that we are going to start being back in the court building sooner rather than later. And usually there are at least 2 court hearings for financial remedy proceedings. One is called the first appointment and one is called the financial dispute resolution. The financial dispute resolution, judges will always refer to that almost as them trying to mediate between the parties. It really is a last opportunity for the judge to give an indication of how they might be minded to resolve the matter and really help the parties to focus on an agreement. If they can reach an agreement, that would be incorporated into a consent order. And if they can't, it would then go to a final hearing with a different judge. That hearing would then take place and the judge would listen to evidence for both parties and would then make an order that he deemed fair and reasonable. So financial remedy proceedings can be quite costly, and generally it is advisable to have advice throughout those proceedings on the different orders that can be made and what would be taken into consideration, and would generally take anywhere between 4 to 6 to 7 months to be resolved. So if possible, parties should obviously try and reach an agreement. It will be quicker, it will be cheaper, it will be more amicable, but financial remedy proceedings are there to help people who just can't do that. Thanks for watching. I hope that was valuable. If you want to contact us about any more family law issues, please get in touch using the details on screen.